arbitration institutions in India. Now, Cinica is an arbitration institution recognized by the Government of India, one among the 50 centers. Cinica has also successfully launched its online dispute resolution platform, and it is progressing well. Today, we have the privilege of welcoming two distinguished guests who have come to share their expertise in the field of mediation. Dr. Chandrika Subramaniam, who is a highly qualified lawyer and mediator with extensive experience in various fields, including law, education, and community service. She has been conferred with 2 doctorates so far, and the latest one was conferred in the last week, and our best wishes to her. And we are happy that she are getting more and more doctorates. Oh. And she is a trainer for the BLA Diaking Institute and a blockchain consultant. She has written about 52 books and has a special interest in mediation, governance, international and humanitarian law, women, ethics, media, management, and leadership. She has won several awards and achievements, including the Premier's Harmony Medal winner 2019, Citizen of the Year 2019, and the Woman of the West 2012. And above all, we're happy to have Dr. Subramaniam. He is one of the advisory board members of Cinica. We are also going to have virtually with us today Mr. Abraham Kuran, who is naturally accredited mediator and a family dispute resolution practitioner since 1983. Mr. Kuran is a conflict resolution practitioner, facilitator, and a trainer. He has worked as a child protection specialist and senior policy advisor. He was also a course coordinator and lecturer with the University of Sydney, teaching mediation, theory, and practice. And Mr. Abe is in virtual mode. Welcome, Mr. Abe. Good morning. He was also a course coordinator and lecturer teaching mediation and theory and practice in the 4th graduate program. Mr. Kudan is skilled and experienced in youth justice conferencing, family decision making, and restorative justice. As we all know, mediation has emerged as a popular alternative dispute resolution mechanism in recent times, and the need for trained and young mediators is on the rise. Mediation can be successful in the Indian family, society, and business scenario. The Singapore Mediation Convention is an international treaty which promotes the use of mediation in resolving cross-border disputes. With India being a signatory to the convention, the need for trained mediators has become even more vital. We all know the mediation has become mandatory. So the Commercial Courts Act mandates the pre-mediation even before numbering a suit. Likewise, there is a mediation in consumer forums. The consumer forum, it mandates the resolving the disputes through mediation. Likewise, in the bankruptcy and insolvency laws, they mandates for resolution of disputes through mediation. So, for keeping in mind in all these things, Cinica has organized this workshop, which will be an intensive one-day program designed by well-experienced and reputed trainers, Mr. Abe and Dr. Subramaniam. The workshop highlights the difference between mediation and litigation, and the importance of law and the ethics in mediation. We thank Dr. Chandrika Subramaniam and Mr. A for joining us today and sharing their valuable insights and knowledge. We hope that this workshop will be beneficial to all the participants and will help you all in your future endeavors. We are going to have 2 breaks during this mediation training session. One is for lunch by 1 p.m. and another one is for tea by 3:45 p.m. By 4 p.m., former judge of the Madras High Court Justice K. Venkatraman is going to join with us for officially launching the book, The Practitioner's Guide to Mediation, authored by our trainers, Mr. A. and Dr. Chandrika Subramaniam. And the Honorable Justice is also going to launch Cinica's redesigned website. Thank you all for your attention, and I hope that you will enjoy the mediation training workshop. Thank you once again. Yes, we can.
Thank you very much for this wonderful opportunity of meeting the young lawyers, experienced mediators, and other legal eagles here. Being a Saturday, I didn't expect more than 10 people, and I'm very happy that we have got more than 15 or 20 here. The whole idea of this session is not to make you an expert overnight. It's just to give an eye opener about how the mediation works elsewhere, not in India, because we have been doing this for so many years. And Mediation Act, a bill is on the way, so it will become an act. So I have included one session on an overview of the bill or the proposed act or whatever it is. So I will be just briefly talking for 2 minutes, and Abe will take over, and he will be mainly doing the introduction to mediation. And then the second session will be skills required for mediation, where I'll be talking about communication and negotiation. Then following that, Abe will be doing framing, reframing, and evaluating options. After that session, the third session, I will be doing mediation versus litigation. That will be a short session. And I will be giving some handouts about negotiation practice related exercise. Then we'll break for lunch, okay? Then the following thing will be coming after the lunch, so I'm not going into that. What is your understanding about mediation? Anyone can, but how will you define mediation? What is your understanding? Have you done mediation, or have you done anything in your life like mediating between two people? Are you able to pick up what I'm talking? Am I too fast? No, that's fine, thank you. Yeah, what is I don't want the definition, just what is your understanding about mediation?
About understanding, developing a consensus between two parties.
Consensus, yes.
And to settle a deal or a kind of agreement between both in terms of any differences of any kind of relating a contractual obligations, I'd like to say.
Okay, basically there's an issue, a conflict, which two parties are not agreeing for anything. So you bring them to a mediation table, then you try to negotiate. And at the end of the negotiation and communication and all the process of mediation, they come to a situation. It has to be a win-win situation. What happens with the court is, if you go to the court, it's win or lose. One party wins, the other party loses. But whereas in mediation, it's win-win situation, everybody is happy. So that's the basic thing. With that introduction, may I ask you to continue with your introduction to mediation session?
Thank you, Dr. Chandrika, and thank you for inviting me. And thank you, Dr. Saravan, for inviting me and being here this morning. I'm really happy to see that most of the participants are lawyers or in the process of becoming lawyers. And this reminds me of one thing. When we started in Australia mediation, there was a lot of opposition from lawyers, believing that is a threat to their jobs. This has changed a lot. 8 years later, from 83 to 91, we advertised for 26 positions as mediators. And would you believe it? There were about 300 applicants who were lawyers, because they can see the value of mediation. So mediation really is something that we all need to have, not just as a profession, but as a skill as well. Being a lawyer, mediation is an important part of your work. Being a public servant is an important part of your work. Conflict management is about communication, about everything else that we all do every day of the week, at work, at home, in social, everywhere. Mediation is really about a skill in how you work and how you manage your relationships at every different area of your life. So mediation is really important. But when Dr. Chandrika asked, what is mediation? I can only define it in one thing. It's about the language, communication, and Chandrika will talk about it later. It's about the language. It's about how we communicate with each other. Either we make it worse or we make it better. I'm going to show you something here, and I would like to ask you, can I share a screen?
You had to give access to screen share.
Screen share.
Assistant. Anyone can have the.
Okay, you can share, I believe.
I can, okay, yep.
Yeah.
Okay. Oh, sorry. Can everyone see this screen?
Stop one.
Can you see it? I would like to ask you, what do you see here?
You can share now. Have
Yeah,
you?
I have. It is shared.
Okay.
Can you see it?
Yeah. We can see something. Some scribbling.
Okay. What can you see in the screen?
You're not able to see?
Yes.
Yeah, I can see here, but give me a second, Ed. Yeah.
Sorry. Can you see it?
Oh,
I've got a blank sheet.
yeah, just give me a second. They're fixing it
Okay.
because you are pinned to the screen.
Okay. I mean, if you can't share it, it's okay. I'll talk about it.
ID.
Yeah.
Okay. Can you
it?
see it?
Yeah.
Okay. Can I ask you, what do you see on the screen? Anyone can tell me?
Scribbling is there.
Sorry.
Scribbling.
The scribbling or a black dot.
Okay. The reason I showed this slide is because we have a slide there, quite big sheet of paper with a dot in the middle. We notice the dot, but we don't actually talk about the rest of it. We notice about whatever is there. That attacks our attention. In conflict, people focus on what they see that is there, but they don't see the rest of it. In relationships, sometimes you have the best relationship with someone and something small goes wrong. We focus on what went wrong rather than everything else that's being good. And that's really what the people, when they are in conflict, when they focus on the negativity, no matter how small, and no matter how big the positive aspects of their relationship. Okay, so it's really important that we are looking at the positive part. Our job as mediators is to redivert the attention, not only at the black spot only. We're not going to ignore it. It is there. But at the same time, we want to show what other positive things in that relationship or in that project or deal or whatever the conflict is all about. And this is our job. It's important that we are actually be the third eye. Because when I'm in conflict, I'm busy thinking about what I want rather than what is really I need. Is that all what I want? to wipe off that piece of the black spot or something else. Mediators are really agents of change. We change the perspective of the parties about what they see, not because what they see is wrong, but what they see is their focus, and they don't focus on the other aspects. When I'm locked up in conflict, I'm only looking at that particular spot without looking at the rest of the screen that is white, clean, and could be used for anything else. Okay, so it's important that that's really what mediation is about. We all are mediators. We born mediators. Mediation has been with us for centuries, for many, many, many centuries, from the Stone Age until today. We've been practicing mediation. However, we've been practicing it in different ways. But at the basic thing, we actually negotiate about our needs. We parted. If you remember many centuries in the Stone Age and beyond, we used to barter. I give you this, you give me that. Well, there was no money. It's about service for service or object for object. And that's negotiation. What is mine worth and what is yours worth? Are they equal in value? So we used to really negotiate. We negotiate with ourselves every morning. What do I eat? What time I want to leave the home? What I dress? What I do? Who I'm going to see today? We do that all the time. But it is important that we actually be aware of our needs first before I ask others to meet my needs. And that's what mediation is about, is really getting the parties to change perspective from the I, this is what I want, to what the others needs. And work and the conflict should be owned by all parties, not just one. We should not be, because in conflict, I blame everyone else except myself. And as a mediator, it's really about to see what is my role as a party in creating this conflict. Some people say, I have nothing. He started it, she started it. But is it? The fact is, I am part of that conflict. It doesn't matter who started it. What matters is how we overcome this, how we meet the challenge and go beyond, how we salvage whatever relationship is there and improve on it. Mediators have one very important principle: do no harm. We should not interfere in conflict if we believe the parties will be worse off. We only interfere or they get involved if we believe that we can help the parties get better. Okay, any questions?
Anyone has any questions? Go on.
Okay, I can't see everybody, so yeah. But I'd just like to add one more thing about the mediator's role. The mediator is about being able to see things that the parties don't see. And I'll be talking about it later on in the morning session. It's about the mediator being able to see it. Because if you look at the parties, they only see their problem. The mediator can see beyond the problem, potential, what the party could do. I'm not going to solve their problem, but it's like, I'll give you an analogy, like a bus driver having people on board, passengers, and driving in the middle of the night, but has no lights. The mediator's role is to shine the torch on the road and let the driver see the road and get to their destination safely. I'm not going to drive the bus for them, but I'm going to show them the way how to get to their destination themselves. That's really what mediate is all about. I just put options for them. And the creating option is one of the most important part of the skills of a mediator. I had one student, high police ranking police officer, in my course at the university. And when the course finished, she approached me and she said, I have 60 police officers that I would like to train them in mediation. I said, are they going to be mediators? She said, no, but I want them to learn how to negotiate and how to work with the public in a positive way. And mediation would give them that skill, will allow them to work with the public without creating conflict. Most of my students were public servants, and part of the public servants' jobs and role is about being skilled in conflict management. Mediation gives them that. Mediation is not just about resolving conflict. It's about preventing conflict. It's about building relationships. It's about everything else that enhances our skill in relating to other people at work, at home, or everywhere else. Thank you. Back to you, Dr. Chandrasekhar.
Thank you, Abe. You will be joining after my 2 sessions, framing,
Yes.
reframing, evaluating options. And not of swingers. Yeah. Okay, thank you. Thank you. Yeah, thank you. Okay, so you had a basic understanding of mediation, what's been explained by Abe. This is one slide I prepared just to give you an overview of that. Hopefully you'll be getting a book at the end of the program, or I don't know whether when I'm going to distribute or already circulated. So most of the stuff are there. Some of them are not there, like the mediation bill, which is a proposed bill that will be added. So why we did it? It's a pre-publication book. We released it so that all of you, at the end of the book, you will find my email. Please go through it, and anything you feel that we have missed, please email us so that we can add that before we finalize the final book. That will be the property of Sinica, and we hope that will be a very good guidebook for anyone who's trying to practice mediation for the first time. Especially lawyers know they can interpret legislation and understand. We have something called community mediation included in the bill, which I am very keen. Abe is an expert teaching that, and I'm also very keen to develop people for mediation. Anyone who has a good stand in the community or people who really peace lovers can become a mediator. So this book aims to do is to train such people to give the skill of mediating. Mediation is not a new thing for us. We had panchayats, we had all the grammar sevakas, where we had initially the olden days, one of the elder will call people who are in disputes and sort it out. So this is not new to us. It's new to the Westerners, but not to us. So if this can be developed, half the load of the courts will be released. We don't need to go to court for everything. I get clients when I tell them, don't go to the court because you come with one paper with the issue. By the time I start communicating with the court, in a month's time, it will be 1,000 pages. And by the time you end this, it'll be about 3 to 4 years, about 10,000 pages of paper and thousands of dollars you pay for the lawyer. So try to negotiate, we'll go for mediation. Most of our people, especially the Indians in Australia, they always feel, no, I want justice. Justice doesn't come just like that. It comes with paper, or black and white, and also money, colored papers. So they don't understand, but slowly people start realizing they pay a big money to get that kind of a stuff. So today's thing, the role of mediator, I've just put some slides, which is also in your book. And the second is when to mediate. When will you decide, we're not going for the litigation, we're going to go for the mediation. How will you decide that? Anyone?
The agreement is there, when a clause in the agreement.
If there's no agreement, you got husband and wife. They say that we want the property settlement. We want to fight in the court. I have the right. You suggest, no, you go for mediation. I do that all the time. And people think that I can't go to court. It's not that. I don't like to go to court because they'll be crying, and the money comes to us with the tears. So which I don't like. Okay. So what will you say? When will you determine the appropriateness of mediation? How will you tell? Husband and wife coming for 2 houses, they are fighting. When will you determine?
The parties themselves want to refer to mediation.
Yeah.
To have an amicable settlement.
That is their choice. But when will you say this? If you go to the court, it's not going to worth it.
It's not solved. But we can proceed as problem for the third person as the mediator to solve it.
Okay. Suppose you have 2 houses, which is just 200,000. Each is 200,000. You don't get a house of that price, but still giving an example. If you want to divide that and the lawyer's fee and everything you calculate for $400,000, lawyer's fee will be $100,000 rupees, so whatever it is. And then they get 150,000. It's not worth going to the court, isn't it? The court costs everything. So if it is not worth the time, money, and the effort, you always determine that it is appropriate for mediation. Factors favoring mediation. How will you decide that? What are the factors you think favoring mediation? Come on, you have to tell me.
Speed disposal. We can choose something easily. We can find the solution immediately.
Yeah.
Without having any time consuming.
Yeah. If you think that it's going to go up to the Supreme Court or somewhere, or to the High Court or whatever it is, here you have the Supreme Court in the state and High Court. High Court in state, and for us, Supreme Court in state, High Court is in Canberra. So only one High Court we have. So it's the other way. Okay. So if you think that it's going to go for years and years and
you would say one more informed litigation, I would say. Mediation is in there.
And okay. Unsuitable for mediation. How will you decide that this one case is not suitable for mediation?
And that is custody of children we are doing for mediation.
Mm.
With the family members.
Yes.
Custody of children is very, very, nowadays we can see.
It's a very sensitive and very time consuming and very emotional also.
Court is also finding very difficult to find out.
For us, it's compulsory mediation. We go for conciliation conference. And before that, if there's a child is involved and the psychological stuff, we get a psychologist to come. Then we sort it out. Most of the 70% is sorted out of court. And then you go to the magistrate, again, give the option. There will be a few issues which are sorted. Then he will give options. These are the options. And they have to agree, or if they can't agree, they can go further and fight about it. But at least 70% will be sorted out.
Recently, Australia has enacted a law to that effect.
Yes.
To have a mediation for custody.
Yeah.
And
because the
in the recent case also, ma'am, the CP matter, mediator was appointed. He gave, viable solutions for both sides.
Mm.
And both the parties now come to a conclusion that having child, custody of child,
yes.
Father and mother. Because of the mediation only, the court has also kind of
Court-directed mediation.
The work of the court is been reduced.
Yeah, the scenario in Australia is different because if you want to get a divorce, It's not very hard there. Just if you prove that one of the parties citizen or a permanent resident, that's first requirement. There is a valid marriage, there's a marriage certificate. If you can't provide a marriage certificate 40, 50 years back, if you have photo or somebody give an affidavit, the priest give an affidavit, you prove the marriage, you prove your citizenship or permanent residency, usually resident. The third requirement is you are 12 months separated. We had one case referred by Achudan to me. The husband left, brought the wife and children here, left here, and he went to Kuwait. That is 12 months separation. He didn't talk to them at all. And he proved it that he doesn't have any contact with the wife. He's separated. It's like talak. Just okay, 3 things, okay, fine. And you have to serve the other party all the documents. That's all you have to. If you have an objection about these 3 things, you can object. You can't object about the properties or children, custody or anything. That has to be a separate case. That will go for years. Okay, that's the scenario there. Evaluative mediation or conciliation, what is it? Come on, somebody from behind. It need not be right. So what do you understand? That's all I just want to say. Sometimes as you go with the mediation process itself, the scenarios change and things will be getting reordered and things will be accommodating more issues, and sometimes some of the issues will be sorted. So every stage you will be doing something evaluative, and according to that evaluation, you also change your mediation needs. You may say that you want to reduce the mediation hours. Okay, this is sorted out, so we don't need to have another session. This one is created a new problem, so can we go and do a session on that and sort it out? So that kind of stuff. Then you also think about arbitration and litigation. So if you can sort out by mediation, you don't need to go for the arbitration and litigation. That has to go for the corporate sectors, I would suggest. All the civil and family matters, it can be sorted out by mediation. Okay, what are the skills required for mediation? What you need to know? Open your mouth, that's the first thing. Then communication. Then after opening the mouth, you also say what you want to say. That is negotiation. Do you do negotiation in your life?
Every day.
Every day where?
Every place.
Every place. You are buying a flower or you will be bargaining. So that's negotiation. You want to buy vegetables, you will be bargaining. That is negotiation. You will be negotiating with your children. Okay, if you do finish your studies today by 6 o'clock, I'll take you to the beach. That's negotiation. You will be negotiating with your wife. Okay, if you can do this, then I will definitely make some time to take you out. Okay, so we do negotiation every stage of our life. Negotiation comes with communication. It's a package. So if you don't talk, you won't know. If husband and wife fighting, they don't talk for 1 week. You don't know what she wants you to do, and you won't know what you're supposed to do to her. Unless you open up your mouth and say, I'm angry because you're not coming with me to the village for the wedding, my relative's wedding and stuff. So communication and negotiations are 2 things. And then Abe will be talking about how you frame your communication and how you reframe things to make it very simple. And from that, you come out with 10 options. From the options, you evaluate what are suitable, and accordingly, you will design your mediation. These are the basics of mediation. These are the core skills for mediations, communication, and negotiations. What does decide the context of communication? I'm coming here. Saravanan wants me to talk something. How do I decide what I want to talk? What will decide what's the context of the communication, in other words?
Inputs from the concerned person.
Person who is speaking. If I am the speaker, then I know what I have to speak. So that context is defined there. And again, the person's knowledge. If I am a person from the community who's trying to do the mediation, I'm an elderly person, you start doing it. So you have the skill that you can control the people you can tell. So that's you, your personality and the knowledge. The motive, what is the motive of that meeting where you're communicating? You're trying to get a win-win situation, make a peaceful negotiation, make a peaceful understanding, and come out with a package suitable to either party. Values. Doesn't come the communication just like that. It has a lot of values. Example, I had a client, he's a Sudanese client, husband and wife were fighting. He said, I gave 97 cows to my wife when I got married as dowry. I'm willing to sign the papers, provided she returns the 97 cows. That was given in Sudan, they are in Australia. What will you do? 3 times, so maybe 15 days, a fortnightly meeting. They were coming, and I just started my mediation practice and I didn't know what to do because Sudanese, you know, it's their African background, they get very angry and you have to be very polite and very patiently handle them. What will you do? 2 people coming to you saying, I want my 97 cows back in what I gave in Sudan and I will sign the papers. For him, it's the value. He has a cultural value that the dowry is given to get married to this woman. This woman is ditching me now. I want at least my value. For them, the peasants, it's very important, their agricultural stuff. What will you do? Come on, anyone from back?
I don't know where the cows are. I know where the cows are.
Also sitting somewhere in Sudan. The wife's mother or someone is having. So it's a harassment for me. Every time they come, he says, I believe you like a god, you have to get back my cows. The wife will say, how can I get the cows from there to here? So finally, what I did, I called him one day, I got an airway bill from DHL. I said, here is the DHL thing, here is the tariff. She is willing to do the thing. You have to pay for the transport. So you had to come to that understanding, fill this. 1 kilo is about $200 or something. How many kilos your 97 cows will be, you calculate or talk to them, pay the money, give me the receipt, we will get it transported. Or we'll speak to the airline whether they can get the thing. It disappeared. It disappeared. So the values as some kind of a thing. Again, the interpersonal communication, it has emotions, attitudes, expectations, then we have dispositions. What's the difference between attitudes and emotions? Any family law matter, it's crying. You will be crying, and you will be losing your own integrity also at the end of the thing. Attitudes, sometimes the husband will be willing, I don't want this headache, I'll sort out, okay, let her take the house. But the woman will say, you cheated me, I won't let you go. I see that I get every penny out of you. So this kind of an attitude, sometimes it prolongs the conflict, it never ends the conflict. Expectation, both parties will expect the best for them. Sometimes the husbands are voiceless. They say, okay, I don't want any more stress because the husband must have planned another wedding. So he wants to get rid of that. Okay, let that devil take all the properties. I just want peaceful life. Sometimes the wife will say, I won't let him go and get married again. I'll see that, I'll drag this till the end. So he'll wait another 2-3 years so that the other woman runs away. So these are some of the attitudes and expectations. And then comes the dispositions. Then active listening is one of the important stuff with communication. What is it? Are you actively listening to me?
Yes.
Thank you. Yeah. So what's the difference between listening and active listening?
We should record in our mind what they represented before.
You should grasp.
Yes.
See, I always have a TV in front of me when I do something, and I'll be talking to Saravanan or someone over the phone. So what am I doing? Am I doing active listening? Or am I typing my work? Am I watching the movie? Which one is I doing? I will be, the telephone conversation is more important because it's an official related thing. So I will be actively listening. The TV will be just running just to entertain me. And the typing work it's a monotonous work, like, you do it as an automatic thing. So active listening is you put your mind, soul and stuff, you hear properly, take all the important stuff, and then you also reflect from that. 3 sets of ears. What are the ears? What are the 3 sets of ears? What's being said, whatever the other party is telling you, have to get 100%, like pouring a glass of wine into another glass without even a drop out. How what is being said and being said? How what is being said? Saravanan may be very angry with me one day and said, you said you're coming and doing this program and you're not doing it. Everybody is upset. So the tone he uses, or I can't see the body language over the phone, but when he asserts something by voice, so how it is said, is he really meaning that if I'm not going to come and do this next time, you're out of this office? Or no, because they are eagerly waiting, all the students are waiting, and they really want to do this course. It can be a polite tone also. So how it is said is very important. Sometimes things are not said. Can you give an example for that? Think, guys. What if somebody is communicating with you, they won't tell something, but the conversation will educate you that they're trying to tell something to you, which they are not orally said anything. The communication will say. Suppose I call this one of the client and say, okay, within 7 days, you are supposed to pay this money to my client. And otherwise, I don't know what's going to happen. Okay, I didn't say that I'm going to take a legal action. So it is unwritten and unsaid words. So the same way in many communication, conversation, you can always say something. You can say the way they also understand there's some underlining or underpinning communication going simultaneous. Preparing for active listening, how will you do that? Especially in mediation, we try to have a very serene place where people can sit peacefully, talk to you without exercising a legal kind of, I sit this side and the client sit that side. Sometimes that's why we try to have a sofa where they can sit next to each other, not non-threatening way. And the time and place convenient for the client, and there's no distraction. Sometimes they come with children, so we try to give a separate place for the children. There'll be always a child's room with toys and books, and we'll also have somebody to entertain them. So there's no distraction, mobile phones off and stuff. We try to give a positive emotional environment. What is that? What do you mean by positive emotional environment? You come to me and I said, okay, now today's session is $500 and can you pay it now itself before we start? What will the client be thinking? Okay, it's the money-making machine and I don't want to sit with you and talk. Okay, we just say that you relax and we try to get something amicable for you and your husband. First, I'll talk to you. After I talk to you, I'll talk to him. Then I'll talk to both of you. And then again, I'll talk to the client or your husband about the options you have. And then let your husband decide what he wants to do. And if you're agreeable, then we'll finally sit for the final round. So the way you speak to them will give the confidence that it's a very positive emotional environment existing in that place. Do you do that with your clients as lawyers or any other profession here? Okay, the listening skills also, as a list of stuff, you have to be attentive. You will be following what they are saying. They say five things. You should be able to grasp it and say that, okay, these are the items you want to list and do things. Then reflecting, okay, you said that you want to have the child on weekend. I understand that, but according to the law, you can only have 1 day. We will see what we can do. Paraphrasing, that is again a rephrasing stuff, which is Abe will be doing about framing and reframing. Clarifying question, if you are doubtful of something, you ask question, or if the client is doubtful, they may ask a question to clarify things. At the end of that active listening, you also need to do a summarizing of what you have been discussing for 1 hour. It's a bit of hard work. You have to sit and take notes of everything. The lawyer's work is always with notes. You don't go anywhere without a pen and a paper. So you summarize and say, and you see that every item is listed according to the client's wish, and you communicate, confirm that this is what they want to do. There are 2 things involved in the effective listening process. What are they? Reductionism, rationalization. What is it? What is reductionism? It's the basics of communication. You get 100 information from your client. Your brain has a capacity only, it can retain certain things. Anything I talk more than 20 minutes, nothing will get into anybody's head. That's the basics of communication. Then, rationalization, you may tell, the wife may tell 100 things to, I want this, I want that, I want this. But you as a lawyer or as a mediator, you rationalize which is practical and you can do. Like the example I gave about 97 cows. That's not going to be, I have to be rationally thinking, is it going to be possible and whether we can work it out. What do we do to facilitate, we may rationalize, what can we do? We take all the information, they attribute different causes, whatever presented to you, but transform them into a language simplified so that you and the client come into a same wavelength. You explain to them, this is what you wanted to do. So I'm trying to rephrase it and giving you in the simple thing, point 1, point 2, point 3, point 4. So it is easy for you to work out things. Sometimes she may tell that the children's item is her first item, then say the house in Bangalore we want to settle, and then the money in the thing, and then about a locker where you have 100 kilo gold and stuff. So sometimes you prioritize and rearrange the order of events and the sequences. So that will make the life easy. Whatever you can get rid of easily, you put it as a priority, and you, out of 6 items, 1, 2, 3, you check and you can finish it off. And whatever you can't, then it may go to a magistrate for conciliation. How can you improve active listening? Verbal and non-verbal. What is verbal and non-verbal? When you're talking to the disputants, sometimes he will be nodding, but you can see his body language. It will express that he's not very happy with what you are doing. You make sure that you give a full and accurate understanding in the disputant's situation. You also show your interest, concerns, and empathetic attention. To encourage full, open, and honest communication. Sometimes they may hide something because they are shy to tell something about their sexual life or an extramarital relationship and stuff. So you try to talk to them, understand that you have something which you can't talk to me, but at least put that in the agenda so we'll try to sort it out. More non-directive, client-central style interaction. That is, don't talk to them like a lawyer. As when you become a mediator, you understand you're wearing a different hat. Your lawyer language will never help you as mediator. When you come as a mediator, forget about it. You are an ordinary person who are trying to help your clients with what they want to achieve and make them very comfortable, touch their emotions, sensitive issues, and say, I'm here to help you. I can't make a decision, but I can facilitate this process where you can achieve your goals. Give that confidence to the client. Again, after active listening, you will be also reflecting. That is, parties to become clear about what they're thinking and what they are trying to achieve. And they must be very comfortable that they are being heard. Sometimes some of the lawyers are very nasty. They don't even listen to them. They said, okay, this is the one. Okay, this is the way we can do it. Okay, 1, 2, 3, 4, 5. Okay, $700 bill. Okay, we'll see you next week. So that's not going to be. Client is, see, any customer service client is your God. So you have to justify what you need to do. Achidan knows my phone is always on, and everywhere I travel, when the client calls, at least I'll send a message. I'm in a meeting. I'll call you after 2 hours. Or I'll say I'm 3 days. I'm not free. I will call you after the 3rd day. So it's 24/7. My phone is always. People call me at 5 o'clock in the morning, 12 o'clock in the night. Sometimes it's emergency. Sometimes it's not emergency, but it's an harassment. But still, client is client, and they know that you call her, she will respond and say, this is the scenario, I'm overseas, I can't do anything. But what's the issue? Okay, I'll get one of my staff to call you, and my staff will call. And the time difference between India and Australia is very fine, because I wake up at 4 o'clock to the Australian time, 7 o'clock or 8 o'clock. Then from 4 o'clock Indian time, I will be working for 5 hours, up to 9:30, 10 or 6 hours. All my office works I'll be able to finish. In India, everything starts after 10:30. So it works fine for me. So you can't deny one client without servicing. That is the disaster for your business. The moment you don't respond to the client, whether you're right, wrong, or they blame you, or you owe money, or you have to sort out something, if you don't sort out things with the client, that is disastrous to your business. Number one, it can go, I don't know about here, they can complain to the law society. I called 3 times, she did not respond. She gave a bill for $1,000, it's only $900. She cheated me for $100. So it's always see that the client is heard. That's very important. What are the key points? Words convey data, facts, information. Body language conveys attitude, feelings, and emotions. Everybody agree with that? You also have facts and figures in front of you. There are facts and figures which are not in front of you, but it's shown by the emotions, attitudes, feelings, and body language. The cultural difference. I met Saravanan in one of the conference. I think I spoke about cultural importance of mediation. It's very important because as a lawyer from an Indian background, I was handling the Australian clients. And I was also co-mediating with Australian mediators with Indian clients. So what's happening with that? They don't understand the thing. They said, if you don't like the husband, you just get rid of them. It's not that easy for an Indian woman to do that. There's a lot of, especially people of yesterday generations. That's a very difficult thing. You can't just orally say, okay, get rid of your husband. There are a lot of other things you have to listen to. So the cultural differences is very important. For Australians, I had friends who divorced this month, and the next month or the following month, they get another person. They get married and they live. So this is not our culture. So cultural differences is very important, especially in arbitration. When they come, the arbitrators come from various parts of the world. If they can't come to a cultural alignment, it's going to be a disaster. Yeah. The gesture, facial expression, tone, all these things counts. When you talk to your clients, I get a complaint from all the time from my client. She's very rude. My voice is such, I will be in the middle of something when they say, okay, I will listen to that, I will do that tomorrow. They think that I'm rude to them. It's not that. Then I have to go and apologize and say, sorry, I didn't mean to do that. I was with another client, I couldn't talk to you. But the tone, the facial expression, and it can be the gestures, what you do. If the words and the body language tell you different stories, clarify anything uncomfortable. Sometimes the clients come, the husband tells a story, the wife tells a story. After they leave, my staff will come and take notes. And she said, okay, can I do this, the procedures, this? I said, no, they'll come back and tell me, this is what they want. The husband will tell a different story now. How did you guess it? Because I understand by talking to them, it's by experience also, what they are aiming to do. So it also gives the body language, from the body language and the eye eye contacts, you also find that something hidden. And the husband sometimes come separately and say, no, this is the scenario, I can't do this. So these comes by experience. Okay, now, what is your understanding about communication? Did you get anything, or was it useful, or did you learn anything new, or did you know these things before? I don't need to be an expert in telling those things because I'm just talking to you my experience. So if you know something which has enlightened you today, tell me frankly, did you know all these things or did you learn anything new?
It is about more clarity.
You got some clarity on that. Thank you very much for that.
And
Okay.
specificity.
Yeah.
And the intricacies.
Thank
That
you.
are not new to us.
Ah,
That is
thank- These are things what you know. It's nothing new I'm talking about, but only it's technically it's packaged so that what is helpful for your mediation profession. Negotiation. What is negotiation? Can we negotiate something? I talk 1 minute, then every one of you talk for 1 minute after that. One minute. Can we negotiate that? Are you agreeable? I will talk for 1 minute, something, then I'll get every one of you to talk for 1 minute. Are you agreeable for that? It's a negotiation I'm making. You like me or not? I can't from your facial expression find anything. Okay. I've introduced myself. Saravanan has introduced myself. I'm a mediator. I do a lot of other things. All those things fine. But I don't know any one of you. Can we start with you?
My name is Sendil. And I have practiced before Madras High Court for about 5 years. And later I taken up corporate career and completed 25 years of total experience.
Good.
Practice as well as a corporate experience as a legal head.
Do you enjoy that?
Yes.
Yeah,
really
good.
enjoy.
Yeah. Sarah.
I'm Saravanan. So today is my 32nd
Year of practicing.
year of practicing.
Good. I'm happy that I give you a big hand.
And so the alternative dispute resolution practice, I realize that it's very, it creates a conducive atmosphere to both the
It gives a lot of satisfaction.
satisfaction.
You can get some.
And finally, we are happy to realize that it gives a win-win solution to both the
Yeah.
parties in a particular mediation.
Yeah.
And being a mediator, actually, we should, it's my personal experience, we should not force our decision to the parties.
Yes.
And we should not take a side of particular party.
Yes.
It should be really.
We will be talking about that impartiality.
Yes.
Yeah.
We should facilitate the situation to the parties to arrive at or take
Their own decision.
Their own decision.
Yes.
In fact, I have 2 failure stories in my mediation when you take a side of particular party.
We'll do that when we do that.
Yes.
Yeah. Yeah. Next one.
So they were it's my 20th year of practice. I'm practicing civil side. Normally, we are filing cases after having discussion with the client. But I try my best to resolve the problem. Most of the cases I handled ended in
Win-win situation.
win-win situation because we know I'm very transparent with my client, and I will both on the other side advocates, if they are cooperating, definitely we are going for a mediation and solve the issues. Before the clients are very happy with us, me, and I hope that the mediation is very, very useful for to find a solution. And litigation also is very important. If the mediation fails, that is the only way out. Because in India, if mediation is not, hopeful that they have to go approach the only court of law.
Were you actively listening to me?
Yes.
What was my question? I said, everybody introduce well for 1 minute. I never asked any opinion about anything else.
But,
No, I'm not humiliating you. Just trying to say that's the thing I just wanted.
mediation is very simple.
No, we are not talking about mediation. I just wanted you to introduce yourself.
Yes, ma'am.
1 minute I talk and 1 minute you talk.
Yes, ma'am.
Okay?
That's
Next one.
very simple topic here, man. It's understanding of mediation. I can understand very simply from you.
Okay, thank
That
you.
it's very useful for me to understand what is mediation.
Thank you.
I have been practicing for the last 12 years. I was practicing under the surround sir. Associates for the last 8 years. For the last 1.5 years, I have been practicing independently. So it's a very, especially I was practicing under this sir, but the past associates mostly they were taking only the ADR, especially arbitration. And here I learned many things regarding the ADR, especially the arbitration.
Okay.
I used to attend the mediation very rare, occasionally, but some cases I used to refer the mediation before. So I have the little.
See, once the bill comes, bill becomes the act. I don't know how long it will take here. Then there is a big scope for mediation. Because arbitration is mainly taken by the big banks and corporate sectors and commercial thing. Sometimes court-elected arbitration taken by individuals, but mediation is in everyday life. Simple things, you fight for a fence, you fight for a construction and stuff. So next.
Yeah, I'm Mohan Advocate. I myself and Mr. Saravanan emanate from the same senior, Mr. K.T. Palpatyan. And I'm also practicing for around 32 years. And I started my practice at High Court, Chennai. And in around 94, I returned back to my native place and I had my practice there along with my business, father's business.
Okay.
And after 15 years, I came back again to Chennai and started with the project finance practice with Link Legal India Law Services. It is one of the largest firm in India. And then I came to again with Saravanan and I have been continuing with Sinika.
Thank you.
Yes, my name is Kishore Kumar. Incidentally, I'm not a lawyer. I'm a chartered accountant by.
And we really want chartered accountants to come into mediation. Yeah.
I'm practicing on both the direct and indirect tax front.
Good.
Yes, I'm Prabhakar. I just graduated and getting into the law. I have a idea of getting into mediation.
Good.
So I'm just gonna pursue my LLM.
Yeah.
So I just wanted an idea about it and I'm
Yes.
I'm Mamta. I'm doing my 5-year law course
Okay.
in Soil, Tamil Nadu State Law University.
Okay.
So, yeah.
Myself, Guru Prasad Kadwar. I am pursuing 5 years BCLLB course in School of Excellence. I am doing it for past 3 months in Sinika.
Okay.
Myself, Wapik, I'm under Saran Sarma. Last year, only I completed my course. Today is everything new.
Okay, that's fine. You learn in the course of time. Yeah. Next.
I'm Shreya. I'm doing my 3rd year in law at the School of Excellence. And I have been attending here for the past.
Okay.
Good morning, ma'am. Nice to have you here. I'm Nivedita, advocate, and I'm working in past association under the guidance of 7 and 7.
Okay. Good. Yes. Next.
I have completed my law in 2008. Immediately I joined corporate. Since then I'm still a
Corporate lawyer. Okay. Good. Yeah.
I'm Vivekanandan, working in NBFC last 16 years, making arbitration and mediation. Very useful session.
Thank you.
And scope from further information. I'm up e-discovery program.
Okay. Thank you.
This is Brahmani.
Yeah.
I'm a lawyer by profession. 16 years. Labor service. Risk and compliance.
You will be coming across mediation in future. All the labor stuff is nowadays sorted out by mediation in Australia and even other parts of the world. Yeah. Next one.
Their story is different. They have at least some courts that we will discuss.
Yeah, that's because the lawyers would like to make money. Lawyers are the rich people here and the doctors.
Bala Devi, I've completed law and I'm a homemaker.
But you're trying to do some mediation in future? That you're planning?
Yes.
Yeah, good. Do some mediation, yeah. Next one. Okay. Yeah, Okay. Did you come all the way from Pondicherry? Okay.
I also hear from Pondicherry. I only on hearing was which I prepare my mind myself to more on mediations.
Thank you.
Morning, I'm George, practicing law for past 14 years. I'm also.
Good.
I'm Sadanand from Chennai. I've been practicing as a lawyer for the past 13 years.
Mm.
I'm interested to take mediations. Yes.
Okay.
My name is Arun Vignesh, and I'm into the rules and all this. I have my own skating academy. This is my fourth day in past education.
So why do you want to do mediation?
I'm much more interested in convincing people.
Oh, negotiation, okay, bargaining.
Practicing other stuff. My fourth day.
Okay, all right, good. Yes,
Nice to have you. My name is Trivikrama, and I work for Past Associates.
Mm.
And I feel like there's a lot of scope in mediation here, basically, because we come from a typical Indian family. There's a lot of negotiation.
it's families, joint families have a lot of negotiations, problems.
And even between parents, you have a chance to negotiate.
Mm.
They have this growing up like that. I learned a lot of negotiation. So I think that mediation is very much important and future.
Yes,
That's right.
thank you. Next one.
I'm Naila Advocate. I was working as a legal associate. Now I'm working for a past associate. It's been 1.5 years.
Mm.
I'm learning arbitration from 7th and 7th.
Good. Okay. Thank you. So we have different kinds of people. We have advocates, we are having other professionals who really would like to, we have housemakers, homemakers who like to do things differently. So what is negotiation? How would you define in your daily life?
Giving options, giving options.
Options, giving options, yes.
Actually, ma'am, I have a doubt. The first question which you had right now was, I'll talk for 1 minute and you talk for 1 minute.
Yeah.
That was actually a negotiation, right?
Yes. We negotiated, we agreed, and you talked for 1 minute. Okay. Then we started talking about active listening, but did you understand what I asked you to do and what you are doing it?
Yes.
So that's how the negotiation works. Why do we have negotiations? You can look at that and tell me there's nothing wrong. No. Why do we have negotiations?
Find a solution.
Parties exchange the information. You give your part of the story and they give their part of the story. Then you also say, okay, for this reason, I want this to be happening. And the other party say, no, for this reason, I want this to be happening. Voluntarily use options, you have negotiation, you try to have, okay, 5 items are there. Okay, I'm agreeable for 3 items, 3 items not agreeable. So we will try to use some options for which party choose what. Privately talk to each other party and also come to some agreement. Further discussion is open, the corridor is open for further discussion, so you can. So when you negotiate, there may be 3 items. From the 3rd item, it may start branching out some new items. So we try to sort out that as well. So overall, you try to bring issues to the table and you negotiate, sort out certain things. There are unsorted items which you would like to sort out. There will be new items cropping up from the existing issues. So this all happens in a negotiation table. These are some of the day-to-day stuff that we experience. Buying a car, we negotiate. You go to Toyota showroom, you want to buy a car, we say some dollar value or rupee value. You say, okay, can you fit extra accessories for me? And I'll buy will you buy the car today itself? Because already somebody has booked it for tomorrow. That's what the cars dealers tell us. You say, okay, if you're fitting me something, Android CarPlay, I'm willing to buy this. So then you negotiate. Salary package, how do you negotiate that? You say that I worked here for 21 years and you have to make me a senior person now. If you're not doing it, I'm leaving. Then you negotiate. There are two people with the thing. I can only accept one person's application for the senior position. So we'll go through the KPI, the key performance indicators, and see who has done what, and you negotiate at that stage. Different roles and responsibilities. Two office assistants always fighting, this is not my work, this is his work. So you bring both of them, sit and negotiate and said, okay, from today onwards, these are the list of the stuff you will be doing. These are the list of stuff you will be doing. Divorce settlements, custody arrangement, that's the daily life of legal professionals to negotiate. Agreeing with the child as a parent, okay, you finish your homework by 8 o'clock, we can take you to the park. Okay, these are some of the scenarios we think about negotiation. Why do we need negotiation in any settlement? Why do we need negotiation? Does the negotiation style differ? Yes?
For the comfort of both the parties.
Yes. You try to get something which is not sorted out. You try to sort it out by talking and negotiating, etc. You give something what they want and you take something you want. Okay. Is there a different style of negotiation according to the situation? Do you agree with that? One example. Think.
The way I negotiate with my senior and the way I negotiate with my colleague.
That's two different things, because you can't go and tell Saravanan, you better get out of this place. Okay, but you can tell your subordinate, no, this is not the way you do things. I think it's high time for you to leave. Okay, what do you think a win-win approach to negotiation would involve?
To the satisfaction of both of them.
Yes, both parties has to take a take-home value, which they don't regret that. Okay, I lost this. Okay, I gave the car to my wife. That's okay. It's 200,000, but I got this house. She's not asking any claim on that house, so I'm getting about 400,000 on that. So things like that. So what do the mediators do for negotiation? When you do the negotiation, what do the mediators do? First thing, consistently every stage summarize. Okay, up to 1:30 to 2:30, we have discussed this. We'll have a break. This is what we agreed. Both of you agree? Okay, tick. Keep that paper away. Then, when they come back and say, no, I made a mistake. I want to go back and do this. I said, no, that is sorted out. We'll go for the new things now. So discourage them not to open the issues. When there is a possible good, positive potential agreement is visible, engage them and walk through them, testing each thing and say these are the benefits, plus and minus of this decision. Are you agreeable to take this? And make them to commit to that. All issues have been dealt with. Sometimes it is useful to take them off. Like, when they come itself, you say, okay, 10 items. Okay, A, B, C, D, you agreed. We are not going to talk about it. I'll say that you agreed and I'm going to put an agreement on that. Then we have E, F, G, H. E, F, G will negotiate. Then from the E, F, G, you may come out with something which needs to be input for the H, I, J, K. So we sit and negotiate. And every stage you repeat what's been summarized and tick that and keep it away. So that way, little by little, like it's like elephant eating. Can you eat an elephant? How many of you can eat elephant? No? Can this room eat an elephant? If I give an elephant, can you eat? No? Why? Vegetarian? No? No, imagine if you are given an elephant, what do you do? You can't eat the whole thing. You have to cut into chunks. You cut the legs, you cut the head, you cut the tail, or whatever it is. Make it chunks and divide among people, make them to digest it. So it's easy to eat that way. Okay, that's one of the management theory. Rational versus emotional. When the mediation is going to, there will be boiling points. People will be screaming, people will be diverting. There won't be any rational thinking. They won't even think we are trying to do something to do good for them. It will be very emotionally packaged. So what do? You have to convince them, you have to calm them down and say that we are trying to achieve something for you. Peacefully sit and listen to us first. We will give you all the options. Then from that options, you try to work it out. Don't assume things. Sometimes some of the clients, I feel like killing them. Middle of the night, they call me and say, "Ma'am, tomorrow is the court case for me. What if the magistrate says this?" I said, what if it's not a question in court? The magistrate may say anything after going through the paper, but I can't predict things. By experience, there are certain things we can predict. There are certain things which we can't predict. What can we do? So no assumptions, but try to make some assumption that good things are going to happen and you cooperate with us. Winning is very important, isn't it? What is the final product of a mediation? What is the final product of the mediation?
Finding a solution.
Solution. So if you attach emotion, what will happen? If you start crying, if you start screaming, if you start abusing, will that help you? No. You have to keep all your emotions out and at least listen to your mediator and say, okay, sir, you give me these things, I'll think what I can do. Then you ask, verify or clarify, saying that you say that I have to give this house. What will happen to me? Won't I lose 200,000 out of that? Then the mediator will explain, you're losing 200,000 here and you're getting this car worth 200,000. So you're not losing anything. So convince the client to understand, not to force your decision. Understand there are two different things. All the options has to be explained. Convince them to understand those options, not forcing those options. Taking the options is in the hands of the client. Bargaining, distributive win-lose, integrative win-win. Courts is mainly win and lose. One party wins, one party lose. But integrative is you integrate everything so that both parties win-win. It's also called competitive. It's again the same thing in buying situation. Sometimes you buy off things. What would you do? You're fighting for one particular house. You sorted out everything. One particular house. The husband feels that was the first house I bought. Wife feels I did everything for this house and I want to live with my children there. So what will be the situation there?
Necessity.
Yeah, each party has their own necessities. What will you do? The wife says, no, I have two grown-up girls and I want them to get married in this house. The husband says, it is the first house I bought and I don't want to give it. It's out of my money. I bought it before marriage. What will you do in that scenario? Any suggestion?
You will look into who is entitled for that property legally.
No, sometimes a matrimonial house the wife can live in Australia. There's one house, one particular house, you sorted out everything else. One particular house, the husband says, no, I want it for myself. The wife says, I have two grown-up girls. I want the marriage to be done there. So what will we do? Anyone, any suggestion? Think about it. I'm not going to give the solution. You have to tell a solution for me.
Both of them has to be the ultimate.
They don't want to live in the same house. They will kill each other.
Both the parties has to be the ultimate beneficiary and accordingly dispose.
We are not talking about beneficial thing. We are talking about the emotions. Like the husband says, is attached to that because he bought it. He got the first house when he was a bachelor. Wife says, I have two girls. I need this house until they get married at least here.
convince the husband just to get the girls married.
That's the solution. So you come to an agreement, we'll put it in writing. Until the girls are married, your wife will be in that house. And after that, whatever you owe to her, you settle the money, she will be getting out of that house and buying her own property to live. Isn't it a good solution? So her only concern is she needs a big house because she needs to conduct the wedding. So that's one way of doing it. Okay. So you're buying off somebody's thing. I have clients, husband and wife, only married for 10 years. They got 10 houses. They come into some situation where they're divorcing. Both parties fighting for 10 houses. I just ask one simple question. You are very careful about retaining that houses, but you're not careful about retaining your marriage because you have 2 young kids. The kids need both parents. Even the Australian laws or the magistrates will say that kids need both parents. You can't get out of that. So things are there, things are that worse there. People just go and buy house. That's one reason for the divorce also, because when they buy one house, they will put the equity, they work 2 jobs to buy another house, put that equity, then they buy another house. So they become workaholics and they don't stay at home. They'll be just running around like mad hatters and children are spoiled. You have money and wealth and everything, your family life is gone. So what is the ultimate thing? We finish work, you come home and you live. People buy houses about 20 kilometers from some place. By the time they come home, it's 9 o'clock. The next day morning, they go to work. So they don't see each other. So without your family and without your social life, it's not worth working. So the integrative or collaborative win-win thing which we spoke, it's dominant outcome, but which gives a maximized joint outcome. Both the parties get the best. What is best for them, what is best for one party need not be best for the other party. So that's the main thing. The critical points in that integrative or win-win bargain, what are the critical points? You have to have a good strategy that how he thought about it. Okay, until the daughters get married, keep the house. Or as I told for the house, you bring the ABN number, airway bill number, I will be able to organize this. So some strategic thinking. Be clear about what is important. Separate people from problem. What is that? Is the problem and people are the same? People create problem, but are the problems the same as the people? So what's the example you can give? Are you sleepy? Yeah, no. Yeah, okay. What is the difference between how will you separate people from the problem? Here is the problem that the house has to go to someone. The husband is a different person. The wife is a different person. It's not we are trying to sort out between husband and wife fighting. We want to get this house or something. The real problem is the wife needs the house for the time of the children's marriage. The real emotion is the husband says, if my father gave me the money, I bought the first house and I don't want to give it to anyone. I want to live in that rest of my house. So the problem is different from people. Do you understand the difference? So when you try to sort out that and say, okay, your problem is this, your problem is this, but you want to do this and you want to do that, we are separating 4 different things. Each one's problem, 2 problems, and each person is 2 people. So we try to sort it out, then you get the solution. Focus on the interest, not the position. What is that? The same thing. It's not I'm the husband, I should get it. I'm the wife with 2 children, I should get it. It's not the position. It is the interest. The only interest is until the marriage. The only interest is my first house. So separate those things. You can chunk it, you can find solutions. Create options for mutual thing. That's what he did. He said, okay, until the children are married, I won't disturb you. Maybe now they're 16. I'll give you 5 years time. Let them get married. Then we'll go on with that. We always aim for an outcome to be based on some objective standard. The objective standard here is the family has to have a kind of support from each one of them, whether they fight it or whether there's problem or anything. The children are main thing. So we try to help the children to get that objective outcome. What are the 4 main points? Fisher and Urey say, separate the people from the problem. Focus on interest, not positions. Generate many options. There can be some other way also you can think about this problem. Use objective standards. You don't make any subjective standards. You don't try to attach the wife's interest. You don't try to attach the husband's interest. You try to say it's a common interest. It's the children. It's a very objective way you are looking at. What is BATNA? You can read and tell. Have you heard this word before? Anyone from management? Anyone with management experience or education? No. Okay, BATNA is best alternative to a negotiated alternative. What will be the best alternative? What will be the best alternative? Suppose if that's not the solution, what will be the best alternative? For this house problem with 2 young girls. Think about another alternative. What will be the best alternative?
One can arrange the same kind of course.
No, the wife doesn't want to leave that house.
Mainly the interest of the children to be satisfied. So the property can be given to the children.
That's one way. The husband can say that, yes, it's your property, we don't want to do that. But after you, the property can directly go to the children. That's one alternative. So think about different options and make many options for them to design. Planning for negotiation. These are some of the questions. What is the minimum I can accept to resolve the conflict? That's the first question. What is the maximum I can ask for without appearing any serious consequences? What's the minimum I can give away? What's the least I can offer without appearing any problems? Try to predict the answers the other person will have these questions. So one party's questions are this. What is the minimum I can accept? What is the maximum I can give? I can ask. What is the maximum I can give? What is the least or minimum can offer without appearing any problems? The same thing you also should think, the other party also will have the same set of stuff. So what will he think that if he gives that, he will be giving the minimum, he will be expecting the maximum. So it's like, the lawyers think that the other party will come out with these issues. So think about all those things and generate your options. It's not BATNA, it's VATNA, worst alternative to a negotiated agreement. BATNA is best alternative. Sometimes you also think, okay, what will be the worst? What will be you lose if you're not negotiating and doing it properly? How would BATNAs and VATNAs can help you? You can reject certain things, you can accept certain things, thinking about BATNA and VATNA. If you can't reach an agreement, then you can always say the consequences will be there. You can have a very flexible approach saying that this is the BATNA, this is the VATNA, this is the worst thing, this is the best thing we can do, and these are the outcomes of that.
That is what many arbitrators to say. If it doesn't accept,
yeah,
we go to courts, this will take this much,
this much money and this much. Some people die even before they get their thing. Some of the things will give you the bargaining strength, so you can bargain more and more and get something because of BATNA and whatnot. And it will also minimize the disadvantages and maximize the advances. So, interaction, there are 4 key activities in the interaction piece: select options, generate options, educate about the needs and perspectives, build a rapport with the parties and the mediator. All 3 of you have to come to alignment with what we are trying to do, because you are not party A's person, you're not party B's person. You're trying to be a neutral person, facilitate something, which options they are going to choose, and they are going to finalize the thing. So get the options, and you try to generate more options by talking to them, educate them and on the needs and perspectives, and make them to decide. That's the main thing. Additionally, the mediator should create trust. Trust is very important. If they don't trust you, it's not going to work. So people come and tell you, oh, you got money from the other party. That's not going to work in mediation. Mediation, you're a neutral person. Understand each other's point of view, what they're trying to achieve. Establish the negotiation exercise and its joint problem solving process. Understand that it's not them, you, or the other party. 3 of us trying to sit and negotiate so that you do try to solve the problem. Other element is personalities, your own personality and style. Some of them, they are not comfortable with you, so they don't want to come back to you. Physical space, like, sometimes if you're putting a chair across, they are not very comfortable, so you try to arrange the room in a different way. Past interactions, past experience with those clients will also count at that stage. Time pressure, now you're given only 2 weeks to finish this arbitration, so you have to work like anything. Subjective utilities, like, what people and place values on negotiation, so you consider their values. What are their values? You have to find out by talking to them. The communication will help you to do that. Understand the context of the conflict. What are the important personal and organizational consequences of conflicts? What will be the future consequences? You try to sort it out that, and after that, after 3 months, they shouldn't call you and say, you said that he is going to give me this car, he never gave me. So you have to put things in writing and the behavior patterns, how they are they aggressive, or if the wife is amicably settling and the husband is trying to cheat, all those things. Substantive issues, what are the perceptions and feelings? Then the underlying background of factors that have lead into the situation and related feeling. That means you have to understand the background of the issue from the beginning, what all has happened and why they have come to this stage, why they are coming to mediate. So these are some of the stuff. Build rapport. How do you build rapport? Active listening. If you're not listening, then they say that this man made money and I don't want to come back to you. Asking question. If you have doubts, always ask question and clarify. It's not a must that I should understand what all you talk. See, I'm also a human being. I have selective attention. So I have to ask questions and clarify things. The behavioral styles, inclusive language. Sometimes you have to use a language that they are comfortable. Identifying areas of agreement. Okay, out of 15 items, 10 items you agree, tick them. So that'll make your work very easy. Why is educating each other on needs and perspectives important? What do you think about it? You have to educate both parties about what's going on. Why do you need that? Because we need a win-win approach. Unless they understand, they will blindly nodding something will not help you. You have to come to a common ground. Somewhere you come and say, okay, these are some of the stuff we are willing to negotiate. Clarify different perceptions. Expose where needs can be interlocked, and all those things contribute to educating. By educating the client, you will be able to achieve. What are the skills useful to educate each other about needs and perspectives? I statements. I understand. I understand. I can see that you want to do this. Mapping the situation, each and everyone's situation can be mapped. Emotions managing is the hardest thing in mediation. One person will be crying, one person will be angry. You should know how to manage them. ask questions to clarify, active listening, inclusive language. This is again how you make the options. You use your skills to get both parties to agree on certain things and make all the list of options. What are the difficult things you feel that it will be really worrying you while during the negotiation? You try to negotiate. What are the difficult things? Anyone wants to answer? Yeah, adamancy. One party never wants to do anything. Okay. Never wants to do anything. What they want, they think that they just, okay, I'll waste your time. Okay.
Parties used to use loose words.
Loose.
Tempting others, that will create a fight between.
Temper losing. Then irrelevant and misleading answers or questions. Personal attacks. So you will be talking and those two people will be fighting in front of you. Manipulative about things. Unrealistic stuff they will ask, like this 97 cows. Is that realistic that you can get it in Australia? So these are some of the difficult things, and you should know how to intelligently handle that. Past events, you finish something and they still go back to the thing, Ashit, you told me like this on 3rd of January and I really want that an apology from you. You're trying to move on. And why do you want to go back and emotional blackmail? Okay, if you're not agreeing to what I'm asking now, I'll see what I can do.
Third person.
Pardon?
Third person's intervention.
Intervention, sometimes the families mess up things. Accusations each other. I will refer you to the higher authority and stuff. They go and just go to, if husband and wife were working in the same place, they go to the boss and tell this man did this to me. The lady did this to me. You don't need to involve all of it. Your professional relationship is totally different from your personal relationship. So some of these can delay the process. So we don't want to delay the process, because delaying anything in legal or mediation or arbitration or conciliation or alternate dispute, it's money. So we want to do it in the shortest possible time with the best outcome. I have given a scenario, which the car sale thing. Either you can have a break now, come and get those papers, get into 2 groups in each table. One person is buying a car, one person is selling the car, or we can keep it for the last thing. You can have a break and come back for framing and reframing and evaluating options. We'll finish that and do this exercise then, okay? We'll have a short break. Did you enjoy this session, or you have any issues that you want me to fix? Okay, thank you. Thank you. Coffee? Okay. Abe, you can do next after they come back. You can do your framing, reframing.
Yeah, thank you.
Thank you.
So the problem is available in the feedback. You can take it. There are 2 leads. Second one is the issue we are going to.
Screen sharing. Screen sharing. I will put.
Is everyone back?
Somehow to come in.
Okay. Please let me know when you're ready.
Yeah.
Ready?
You can start, Del John.
Okay. Well, thank you very much. That was very interesting presentation, Dr. Chandrika.
Thank you.
I will be touching on some of the things that you talked about in my presentation as well, because they are all overlapping between what you negotiation as well as reframing and reality testing. Now, with my presentation, I'm going to visit the theory of mediation, because we need to put everything in perspective. Why we're doing what we're doing and what we're basing that on. And that's really important for us to really go back to the theory and how we apply it in practice. Okay. And Dr. Chandrika said something about separating the people from the problem. And that's based on the principle of mediation. Separating the problem from the person, the problem becomes in the middle of the table rather than owned by one person or another. Sharing the ownership of the problem is the most important part of mediation. So by taking the problem away from the person, we don't make it a personal conflict. We are looking at the problem rather than at the person. We don't say, if someone says you are idiot, you are bastard, you are stealing my money, you are lying and all that, that's very much personalized attack. Our job here is to take that away and say, okay, by reframing, by saying, okay, I can see you are angry. What are you angry about? What did he do rather than what he is? What did he do to make you angry? He stole my money. And tell me about the money that was stolen, not about he stole the money. Tell me about the money he has stolen. We talk about the money now. We not talk about the person. You see the difference? Immediately we refocus the problem solving on the problem itself rather than the person. The minute we keep it with the person, it's not easy for us to really dislodge the person from their view about the person. And we cannot build trust while the accusation is there. So what we need to do is really make sure that we are talking about the issues, not about the person. We all make mistakes. However, we need to talk about the mistake, not the person who makes the mistakes. Okay, and that's really very important for us to remember when we are dealing with dating. I'm going to share a screen with you now. Just let me see if that's been successful. Okay. Can you see the screen? Okay. You all can see the interest-based negotiation. And this is really important for us to know. When people come to the mediation, we look at the bottom of the pyramid. They come with a position. I want $100,000. I want this. I want that. Okay? They put a gambit of clients. Our job is to walk them up the pyramid. Is that what you claim? What do you want? I want to buy a house with that money. But really, what is that you need? We need to really go back from what we claim to what we need. And this way, what we're doing is we're narrowing the claim and we make it more easy to understand, more easy to manage and to negotiate about. How we do that? By asking questions. And asking the questions about challenging that person once. Okay, and this is really okay. So what we do here, we have the iceberg. I'm not sure if anyone has seen the iceberg theory. The iceberg is We see the top of the iceberg above the water, and that's what the position of the parties. They come with that position, is what we see. But what's behind that position is so much more under the water that holds that position is in place. There's always been said that 3-4 times bigger under the water than what you see above the water. So our job as mediators is really to dive under the water and dig down where that's coming from, where that claim is coming from. By digging down, we start to understand them better. If you don't understand where they're coming from, you'll never understand where they live, where they're going. We need to know where they start or where we finish. If we don't know where they started, how we finish. So the under the water are really the motivation for their position, what their needs are, what their concern, what their fears, what hopes, what is it there? And we need to understand all of that. And we often hear that what drives that behavior. I mean, I did one mediation between two neighbors about an incident that happened 20 years early, but they never talked about. By going under the water, I found out what happened 20 years that has driven that conflict to the point where they came to mediation 20 years later. So it's really important that we are actually work with the parties on the issues that we don't see and they don't present, which is under the water. Okay, please, because I don't see everybody, I might not be able to see if anyone has any questions. Please interrupt me anytime, but I'm not sure how I'm going to, you can send it via the chat if you like. Okay, so this is really where we are going to work with the parties. Reframing skills in mediation are the most sophisticated and challenging communication skill for a mediator to master. It's really important part of the mediator skills base. Unless we understand how to think immediately, on the moment, we may not be able to be in touch with what the parties are talking about. And reframing is really about asking the right questions and also make a blunt attack. In mediation, when people are negotiating, they throw at each other knives, guns, they shoot at each other, I mean, verbally, and they scream and yell and all of that. Our job is to change it from a negative exchange to a positive one. Now, how we do it, and this is what we're going to talk about. Reframing because as you would know, I'm not sure if you're familiar with the stages of the mediation. The stages of the mediation, they are the past, present, future. That's how they are divided. What happened? That's the past. What is happening right now is what we are talking about. Where we want to be, what agreement we want to have is the future. We don't reframe the past. The past is already there. What we reframe is the present and the exploration stage. When parties telling their stories, we don't reframe it. It is their story, and they are entitled to it. I'm not going to change their story. We need to hear it. And everybody in the room needs to hear that story as is, without to discuss the issues in the exploration phase. That's when we start using reframing and rephrasing and asking the right questions. All our questions are open-ended questions. We don't ask questions except in very rare situations. A yes or no answer. Those questions should not be in our books. We ask questions to generate discussion rather than to close the discussion. The best mediation is where the parties are doing more talk and the mediator doing less talk. We listen more and talk less. So reframing involving taking a statement or a concern, then focusing on specific behavior or options to be negotiated related to the statement or concern. Let me give you an example, and I have a few examples I would like to give you. In red there, she is untrustworthy, liar, and would take advantage of her own mother. What that statement means to the party, they don't trust this person. They would be take advantage of their own mother if they can. How can I trust them? How we change that into a positive? We acknowledge the mistrust issue. You are concerned with being treated fairly and honestly. You see what I mean? How we changed it? We take it away from that today and we turn it into what their needs are. Their position, no trust. Their needs is, I want to be fairly treated. I want to be hearing honest response, honest answer, someone who is not lying. You see how that changed? And that's really important. And we need to think immediately. I'm not going to say, stop, just let me think how I'm going to do that. You need to have that in your vocabulary, in your dictionary, in your head. The minute they say it, the minute you talk about it, reframe it. It's too late to go back to it 2 minutes later. And people will not stop because before the minute that is said, the other party will be responding by a defensive attack. And we don't want that to happen. I'm not lying, I'm not doing some that, and there will be an attack and the conflict becomes worse. So the minute that is said, we need to be immediately responding by changing it. We're not actually telling that person you are wrong. We're saying, yes, you have concern about it and you want to be treated fairly. By saying that, that person acknowledges that's really what they're looking for. And that person then start to respond how they're going to treat that person fairly and honestly. You see how we change the narrative? From mistrust to lying and all of that to someone who is willing to work with each other. And willingness to work with each other makes the situation much different and more positive and constructive to each other. The essence of reframing is to clarify and uncover the essence of meanings, needs, interests, or concern from unproductive framing and present it in a new way so that it can be more easily addressed and handled by the parties. If we continue with the lying and mistrust and all of that, they're not going to be handled effectively. And they will be much more further apart than when they started. And as I said earlier, our job is to make the conflict less harm than make it worse. We need to improve the relationship, not make it worse. Reframing is a way of changing the perspective or changing the image. The point in reframing is to offer the parties a different way of seeing the same series of facts or incidents. I've just changed it. I did not take it away from them. I did not say no. I did not defend the other person. I did not agree with the person as well. What I did is actually present it in a different way that allows them to actually be on a better place than where they were before. Why do we reframe? Again, please stop me because I don't see everybody. Please stop me to clarify if there's anything need to clarification. Reframing can be useful in many different ways. To tone down on blaming or critical statement and state in a positive frame. Dr. Chandrika said earlier about the husband who wants to stay in the house because it was his first house and because he wants to be close to the kids and all of those sort of things. Okay? And that would have created a lot of conflict between both the husband and the wife. How would I reframe that? I reframe it on the needs basis. You love your kids, you're passionate about your kids, and you want to be close to them. This is why you're asking to stay in the house. Is there another way you can be close with your kids without having to live here? You see how I opened it up? Acknowledged his needs, I acknowledged his love for his kids, but I also asked him to consider other options. Open up the options for him. I did not argue, look, that's not possible because your wife said no, and whatever. I didn't say that. I said yes. Acknowledge. Because the minute you acknowledge his feelings, his passion, his all of that, he is with you. He's not going to argue with you. And that's important. So you are getting both of them to start to talk about how to facilitate contact with the children while not living together, rather than about arguing about who wants to live where. Two different perspectives, but the same outcome. Okay. We shift the negative to positive. For the wife living in the same house could have created a very negative situation. By reframing it, we change it from negative to positive. The same thing with that person saying he's lying, will steal his mother or all of that. We change it from a negative one to a positive. By just simply play with the words, acknowledge and go into a positive discussion, more productive and constructive one. Identify the needs or concern behind the stated position, which helps the clients to analyze their own perspective and clarify their thoughts. In both situations, when with the person who's accused of being lying and the husband, I looked at their needs. That's important. The husband needs is to have to continue contact with his children and build a relationship with his children after divorce. And for the other person is to be treated fairly. That's his or her need. So by focusing on the need, you are actually getting them back to discuss what's important to them, not what they want. Identify the issue that needs to be resolved. This can be the start of building an agenda. Be careful not to suggest or imply a solution in your reframe. And that's really very important because the job of the mediator is not to solve the problem. The job of the mediator is to guide and lead a discussion by asking the right questions, by asking questions that generate discussion, by reframing and all those sort of skills. What we're looking at here is we focus on their needs and let them negotiate what their needs are and how to meet their needs. When in my reframing, I did not suggest a solution. I didn't say you should go out. All what I said, you bash about your kids, how we can maintain that relationship if you were not there. I didn't say you need to go out or you need to stay in. The same thing with the first person. No, I didn't say, look, he could be mistaken or not lying or whatever. I just said how you want to be treated honestly and fairly. How are you going to manage that? How are you going to achieve it? And let them discuss that. They are the better people to really come up with the answer. To emphasize common concern or common ground. In both situations, I actually touched on the common ground, the common interest about continuation of relationship with the children, and the other one about being fairly treated. And that's really what really connects them. Acknowledge emotions, but not as central focus. I acknowledge the feelings, but I did not make it. Let us talk about your feelings only. We need to talk about your feelings. However, we need to talk about how do you want to be treated fairly. Okay. Any questions, please? Okay, I'll give you more examples about reframing. One party says, we have been at this all day and have not made any progress. It's a very negative statement. My question would be, or my rephrasing is, what can you do to help us get that done? What we need to do to make things better? The other party, I can't trust her because she tries to steal my clients. How would you like her to deal with your clients? Okay. Change the wording a bit and put it back to them. Let them come with the answer. I did not give them solution. I did not take away their statement, but I changed it to create a discussion. Because if you look at the first statement, we have been at this all day, and some people say, well, look, there's no use of us continuing with this discussion. There's no use of us going anywhere. Let us leave. The same thing with the second one. No use of talking to her because she's stealing my clients. I can't trust her. I can't do this. It's the end of a relationship if we allow it to stay there. By reframing it, we actually ask them to continue discussion at different level with a different perspective. I always have a few things up my sleeve to use when I'm doing reframing. And there are some of the examples, and they're not necessarily everything, but there are some I use. And when someone makes a statement, I say, okay, so it is important to you that you are to be treated fairly. You see what I mean? What I understand you to say is, you want to be able to trust her. What you are concerned with is you're not going to be treated fairly, or you're not going to be at a trust level. So we use those sort of phrases and we keep them up our sleeve. So we come up with them immediately. I have them there. It's like a resource. And you always think about things that you can think of, because sometimes you may not be able to come up with something so immediate. But if you have those resources, you can always play with the words to make it more positive. Your language needs to change, not only in mediation, but in everyday living. You need to live the mediator's language, because that's how you start to actually learn how to be a mediator and using the language of a mediator, which is a positive language, simple and open, constructive and inviting. That's the language we use, and reframing is all of that. So we are changing things, negatives to positive. If someone says she is impossible to work with in a group setting, she dominates conversations and gets very upset if she doesn't get her way. I just can't work with her anymore. That's one party says that about the person in the group that who dominant in the discussion and does not allow others to express their views in the meeting. Again, the mediator will say, acknowledge the frustration with her response in the group discussion. Again, when I said acknowledge the frustration, it's about separating the problem from the person. I did not say frustrated with her only, with her response in the group discussion. You cannot work with her because of her group discussion behavior. And at this point, you have given up on working with her. There will be another follow-up question with that. How would you like to work with her? Because in the first statement, it doesn't say, I don't want to work with her. He said, I can't work with her. Two different meanings. If I say I don't want to work with her anymore, that's different than I can't. That means I can't, that means they want to, but they want to be able to. So again, we need to really focus on what the party's words and what they say for us to respond to. We don't make assumption. If they say I can't work with her anymore, doesn't mean they don't want to work with her anymore. I could reframe that again in a different way. Are you saying you want to work with her, but you cannot work at this point in time because of their dominance? You know what I mean? Because you're not able to express your view in the meeting. So we changed the discussion from I can't and I don't to something else, to rebuilding the relationship at different level. Again, more examples. One party says, I'm not saying I can't do anything with her, and this is the same scenario. We can still do this work together on the project, but I won't attend public meetings with her. I just can't stand the constant battles. You are prepared to work with her in most areas, but it is in the meetings you have become really discouraged about working together. So we are actually narrowing the scope of that dislike. That person does not say, I don't want to work with her, full stop. I want to work with her, but not attend meetings with her. Okay? So the relation, we are actually building a relationship at different level. It's not completely lost. This guy is lying through his teeth. What he's saying is complete nonsense. He was the one who came to my house, woke me up, and started shouting at me like an idiot. I never came near his house. Okay? So this statement made by this person is about the other person's behavior towards him. So you disagree strongly with his account that you went to his house. Your memory is that he came to your house and the argument took place there, not at his place. Then I will go immediately ask the other person, what do you say to that? So we're not looking at the accusation, we're looking at the behavior. Okay, and we start to test the facts. Again, more examples. In the open statement, one party discusses the other party always being late for work. The other party mentions that getting to work on time is difficult because of childcare arrangement. This is where we reframe this for our agenda item. And when we're doing the agenda needs to be positive, need to be neutral, and need to be relevant to both sides. So we don't put there in the agenda item as coming late for work, for instance, because that's only relevant to one but not the other. And it is negative. We just talk about working time. What is working time? And let them talk about it. So the reframing starts from the agenda. Okay. Any questions? Okay. Now, am I over time or is Chandrika there?
1 second.
Sorry? Am I over time?
1 second.
Yes, Ed.
Dr. Chandrika, am I over time or I can continue?
You're okay. What's the time now?
It's 4:30. Sorry, it's
Yeah.
12:30
No,
there.
you can go another half an hour and finish it off.
Okay,
I
I'm going to go into the
options
of evaluating options,
Okay.
which is
All right.
I call reality testing.
Yeah. Just finish it off. Yeah.
Okay.
Yeah.
Okay, reality testing is, we do it in the private sessions, at the stage where in the private sessions. I always reframe and don't allow myself to do reality testing during the discussion, joint discussion. And the reason for this, it has more meaning in the private session and better outcome than in joint sessions. And I'll give you an example. If someone says, I want $100,000, and the other person, yes, I'll give you 100,000 in the joint session. That person, we don't know if that person has the 100,000. He may be saying it just to get him off his back and leave, and that's it. We don't want to write an agreement that may not really last the distance. We want to make sure that person has the $100,000 and willing and able to pay it within a certain time frame. that person might think, I can ask my father, my cousin, my whatever, or go to the bank and borrow the money and give it to him. What happens if these people don't give him the money? Have we resolved the problem? Have we actually achieved anything? Of course we're not. We don't achieve anything if we don't test it. Nothing goes in the agreement that is not reality tested. And whatever options the mediator suggests and the parties accept or discuss or whatever, we need to make sure that those options are actually realistic, achievable, and deliverable, and within the means of that person to do it. What happens if that person says, yes, I will pay you, and he goes home and his wife or partner or whoever that they say, no, I'm not doing that. I'm not giving him that money, even if they have the money. So we want to make sure that person who's making the agreement is actually has the authority to sign an agreement and deliver on its items that they agreed on. We cannot get him to sign something when he knows that there could be a third party who is not present in the mediation will veto that agreement or has power over that agreement. So we want to make sure that person is authorized and has the authority fully, legally and personally and morally to deliver on what they agreed on. What I normally do in the private session, if they agree on the exploration stage and they say, yes, I will give you 100,000, I don't say that's an agreement. That's not an agreement. It's an option, a suggestion. When we go into private session, I ask open, direct questions. In the exploration, I ask open-ended questions, not leading, not questions that is really suggestive. It's only my question in exploration is to generate discussion. My questions in the private session are completely different because I'm only with one party. And I want to make sure that party understands what he or she is offering the other. And they understand the ramification or if that doesn't happen. If he says, I want to give him 100,000, do you have $100,000? No. Where are you going to get it from? I don't know. How are you going to offer 100,000 you don't have? Is there any other way you want to make another offer or some other way of paying the money? So we start to look at options. Okay, how much can you afford every month? I can afford to give him 1,000 every month. Would you offer him to pay him $1,000 every month until you have paid the whole amount? Okay? Who else needs to know about this money and the payments? My partner. Would your partner agree to it? I don't know. Would you go and call her now and find out if she would before we sign the agreement? So I give them time to go and make that call. Do you need to discuss that with your lawyer? If that's okay for you to agree to, go and give your lawyer a call and ask if that's okay. All of those sort of, you can do because it's easy and more frank and open. They will be more honest with you and open with you than in joint session because they may not want the other party to know they don't have the money. It will be embarrassing for them. And you don't want to embarrass them further by making an agreement. So reality testing is absolutely important. Dr. Chandrika talked about the Patna, Watna, and I add one more, Mlatna, most likely alternative to negotiated agreement. Most likely. There's the worst scenario, there's the best scenario, and most likely scenario. So I ask if you can't tell the worst scenario, if you can't deliver, what would happen? And we start talk about it, go to court, and the courts maybe ask you to give because whatever. How are you going to do that? Okay. So we need to look at those options and make them aware. What could happen if that happens or doesn't happen? It's important. The other thing about the best scenario is you have the money and you pay them. And that's again, we ask the same question. Now, with the other person, when we have the private session with the other person who's demanding the money, and we ask, what happens if you don't get $100,000? What would you accept? Would you accept half, 3/4, less, more, whatever? Yeah, no, I want the whole money. Then we ask this question, what happens if you don't get the full amount? I go to court. How much would that cost you in legal fees? How long will it take you before even you get to court? 1 year, 2 years? I don't know what the waiting period is. Okay? What happens in the meantime? You're not getting any money. So we start asking those questions. The worst scenario, what happens if you go to court and the court agrees with the other party? Is there a guarantee that you're going to win the case? There's no guarantee. Because the decision is not yours anymore. It's a decision with the judge. And we make them think about their side, because some people come and think, I'm going to win regardless. I have the best lawyer, the best thing, I have the money to fight him, but they don't think how much they're going to pay in the process, how long they're going to wait for an outcome that is not 100% guaranteed that they would win it. Option generation is so important in mediation, especially in the private sessions. If someone says, look, and I have this situation before, where there was money demanded from one person from another. And in the private session, that person who demanded the money, all what he said, I need an apology that he actually caused the damage. I don't want money from him. I fixed the damage, everything is okay now. But I need an apology, an acknowledgement. Acknowledgement is really important to some parties. And we have seen it in defamation cases where getting $1 as compensation would be sufficient because the dollar is an acknowledgement of wrongdoing. It's not the amount. It's about acknowledgement of wrongdoing. And that's very important to some people. Their reputation, their honor, their pride, and their reputation. So we need to ask those questions because it may be not the money. It could be something completely different. And those reality testing will lead us to that sort of situation where we get to understand what is really behind the request, what is behind that demand, by asking what if. What if is very important question to ask. What if they don't pay? What if they cannot pay? What if they only can give you installments? What if this? All of those what ifs are really important when we are working with the clients in private sessions. And the private session give them that we don't embarrass them in front of each other. We give them the space, safety of being honest and open and transparent because they trust you. And that's very important. And you're not telling them what to do and how to do it. You are helping them to understand themselves and their situation much better. And I always repeat one thing. William Ury, who is an international mediator, once said, I can make the best speech when I'm angry that I will always regret. During the exploration, people are angry and they say a lot of things they don't mean it. But when you have them in the private sessions, they're much more reasonable. They may be still feeling angry, but your questions and your interaction with them put them at ease and they start to go in a rational manner, discussing the issues. While they are emotional and irrational, you'll not be able to get anywhere with them. Okay? Any questions? I'm going to show you a very short video. And it is a quiz. And I would like you, because that's a part of the option generation, how to resolve conflict. And I just want you, when you watch, I'm not going to give you the answer. I'm going to give you the quiz. But I would like you to solve it and talk to each other one-to-one. Sorry. Talk to each other and try to resolve it. Okay? Okay. Okay, can you see it?
Yes.
Okay. The question here, a man died and he left 17 camels to his 3 sons. So 17 camels to 3 sons. Okay?
His 3 sons, 17 camels. And to the first son, he left half the camels. To the second son, he left a third of the camels. And to the younger son, he left a ninth of the camels. Oh, okay.
Okay. The first son, half of the camels. Second son, a third of the camels. Third son, 1/9 of the camels.
His sons got into a negotiation. 17 doesn't divide by 2. It doesn't divide by 3. It doesn't divide by 9.
Okay. So have you got the quiz? We have 3 sons, 17 camels. The first son, half of the camels. The second son, 1/3. And the third son, 1/9. How would you resolve this issue without killing any of the camels? I'll give you 2 or 3 minutes just to think about it.
You shouldn't sleep.
Any answers?
We have a scene in a cinema.
Sorry?
But if-
That is- get up.
Technology is that. Technology solved this issue by bringing another camera.
Anybody solved?
First.
You want to solve it, Ed?
Okay. I'll share the screen again.
Presently, temper started to get strained. Finally, in desperation, they went and they consulted a wise old woman. The wise old woman thought about their problem for a long time, and finally she came back and said, well, I don't know if I can help you, but at least if you want, you can have my camel. So then they had 18 camels. The first son took his half of 18 is 9. The second son took his third, is 6. The youngest son took his 9. A ninth of 18 is 2. The 17. They had 1 camel left over. They gave it back to the wise old woman. Now, if you think about that story for a moment, I think it resembles a lot of the difficult negotiations we get involved in. You start off like 17 camels, no way to resolve it. Somehow what we need to do is step back from those situations, like that wise old woman, look at the situation through fresh eyes and come up with an 18th camel. Now, finding that 18th camel in the world's conflict has been my life passion. I basically see humanity a bit like those 3 brothers. Well,
What do you think?
Yeah, that's a wise advice.
Any comments?
Mediator should have a very wise thinking.
And out of the scare.
Yes.
What we need, sorry?
He has to work out the strategy.
Strategies, creative strategy.
Like William said, we need to look at the situation with the fresh eyes. That's our job.
Please, new ways to advise. Either way, whatever, find new ways to solve the issue.
Yep. So that, sorry,
New ways to find out a solution, solve the solution, solve the issue. New way. Opportunity we have to create. We have to find a new solutions by choosing either way.
so is that the question or a comment?
My comment.
Yeah. Here, the mediator has the ability to be removed away from the conflict because they're not part of the conflict. They move away from the conflict. And by moving away from the conflict, they are actually can see things differently. They're not locked in. When people, similar to what I showed you earlier with the dot in the middle of the paper, people focus on that dot. And when they focus on one thing, they can't see the rest, other options. Our job is to create the option because we see it differently and we see a bigger picture. We ask a lot of questions. And always when I'm asking the question, I always remind myself, I'm asking it for the benefit of the party, not because my curiosity. I want to know a bit more about that. It's nothing to do with it. It's really about the parties to create a better way for them to understand themselves, understand the conflict, understand the other. And this in turn, I'll show you one more slide. And I'll finish it with this. So I'm just there. It's really moving the parties from, oh, no, it's not there, sorry. It's not there. It's about moving the parties. When the parties come to you, they talk about their story. They talk about the I, my story. When they start the exploration and the discussion, they start to listen to each other's story about you, each other. In the private session and the negotiation for the agreement, they start to talk about we. We move them from the I to you to we, past, present, future. That's how we do it. We listen to your story, listen to each other's story. How are you going to help each other? There are the three stages of the mediation. Past, present, future. What we want to walk away with. And that's really important to follow those sort of three stages because we don't want to confuse one with the other. The minute we confuse them, we don't know if we're going east or west. We need to go in one direction. And that's you who is in control of that. Any questions? Okay, I'll leave it back to you, Dr. Chandrika.
Yeah, thank you very much. Yeah. I'll do the short session on litigation versus mediation, and then we'll break for lunch. Martin. Okay, how did you go with the last two sessions? We'll have a very short session so that you can must be hungry. This is only a few slides, so I'll finish it off this as planned, and then we'll go for lunch. Okay. How did you go with the framing, reframing, and stuff? Was it helpful? The camel story is good, isn't it? Yeah, you have to think out of the scare and try to do something creative. Even I thought the same way. You add one more camel and then divide, and then whatever left over, you can take it. I didn't do the calculation, but I really thought that way. Okay. Litigation versus mediation. Saravanan said he enjoys mediation rather than litigation. So he's able to give some good solutions to the people. So what's the difference between litigation? What is the difference experience between litigation and mediation, you think?
The procedure involved.
The procedure involved.
Conversion process,
Cost involved, time
time.
involved, technicality involved. What else? You need a lawyer, you may have a counsel, you may have a senior counsel, the hierarchy of a bunch of professionals and stuff. Okay.
Procedures to be followed.
The judicial process, so you have to be bound by all the judicial instructions or legislations which guide you. See, different courts have different legislations about filing, about serving, and how many points. For us, it's very difficult. That's why I stopped litigation, because it very particularly they'll say you have to have 2 centimeter margin left side, 1 centimeter margin right side. Then you have to number this way and all. It takes enormous admin work before you quote. When we do the court work, it is, in my experience, you do 90% of your work in your workplace. You finish everything, you go in front of the magistrate. The magistrates don't have time to listen to your stories. You just go and say, this is the point, this is the scale, this is what I'm trying to argue, and I'm placing my arguments. Then within 1 hour, you should be able to tell everything what you want to tell. But all the stuff, you do it at home, and then you'll be able to quote it, then the magistrate will take note of it, which is very laborious process. And you need so many manpower, like one person has to do the photocopying, one person has to do the document ready. There are professional document makers in Australia. If you give the whole case, they know where to put what, and they'll ask. So if you're missing something, they'll call and say, okay, AA team notes are not there. Can you please send me that? And they professionally make it. They make big money out of it. For small litigation itself, we made about $5,000 to make the paperwork. If it's a big one, they make about $100,000. So it is all money minting mechanism and nothing else. So it's a judicial process, and it's based on a statutory and determinative process. The statute will tell you what needs to be done, and you have to follow all those stuff. What are the characteristics of courts and court-like process? How many of you have gone to a court? Students, lawyers. So do you love that place?
Yes.
Because that's your bread and butter. Yeah. Somebody came from here and asked me, they wanted to go to a court. And they said, do they argue? I said, you won't get Shivaji Ganeshan in these courts, because the judge will just take you out of the court and say, stages, you're wasting my time. So there you have to very simplicity. It will be like this. There'll be a magistrate or someone sitting, or 5 judges or whatever it is, in a higher place, and there will be 2 counsels sitting, and very quiet place and very nicely presented case. You won't get the Shivaji Ganeshans there. So the thing is, if you go to the court, you have to follow all the procedures. That process is very it's a vexatious process sometimes, and it has its own advantages and disadvantages. So what are the advantages of going to court?
Decorum you have to follow. It's a contemporary and following it.
Yeah. What is the advantage of going for mediation rather than going to court? Saravanan can say that.
You don't need to follow any procedures.
Yeah, there's no strict,
rigid.
there's no rigid rules, very informal, and They consider the surrounding circumstances, whereas in law, it's black and white, whatever the law says, you have to follow. Yes, you were trying to say something?
No, I was just trying to say that mediation should bring the client, like the person who's approaching for help, a better solution than litigation. As
Yeah.
you said, it's black and white.
Yes, and you don't need to follow strict rules and stuff.
And you can consider many other scenarios that will not be considered in a litigation process.
Yeah. And,
They speak in friendly manner.
yeah. So it makes everybody comfortable. Also, sometimes the clients go to the court and they get sick by seeing the magistrate or the rules. And sometimes the magistrate also tell you in a very harsh way, and you can't take it and all those things. So you're just getting the conflict away from the traditional way. And it's all form of external adversarial state sanctioned processes. Everything is combined in litigation. Whereas this is, there are many quasi-judicial organizations also like AATN, which is Administrative Appeals Tribunals. So they are quasi-judicial nature, you know, they are not very strict at the same time. They also follow strict rules and regulations. Disputes not suitable for formal judicial process. What is that? What are they? How do you recognize that? How will you analyze that? By what way? You can say these are not for judicial, we'll go for mediation and finish it off. Not all matrimonials. You can't generalize it case by case. If it is a time consuming, it's not cost effective, and the amount involved in that is not worth going to court and spending $50,000. I tell all the clients, easy $70,000 to $100,000 if you're going to fight in the court. Go for mediation, finish it off. They won't listen. At the end of the day, some of those big lawyers in Australia, they charge about, the billing is about $100,000 for a family law matter. So it's cost effective, time effective, how far you can go and all those things. This is the thing. So there are some stuff there about the cost, the time, the relationship, lack of legal basis, you can't go, you need to engage lawyers, publicity, predefined options, lack of control, fixed process, lack of evidence. So if you're going to court, it has to be black and white. You have to put every paper you put, you also give an evidence for that. Where did you get this? So if you don't have evidence, it's no point going and fighting. So all those things, that's in the book, you can see that because it's not very legible here. Mediation is always a better proven, better option than the litigation. The Community Justice Center in New South Wales found that 86%, if I'm right, yes, 85% cases are successful. So people go for community justice centers. So like simple matters like the fence, the neighbor problem, or if somebody is not giving pathway to you to go to your house and all those things, it goes to refer to community justice center and it gets sorted out. And most of the family law matters nowadays, it's all pre-mediation, mediation, and then they also come with conciliation conference. There will be one conciliation conference with the magistrate. He will finalize most of the stuff from what they have come. And then what is not there, they go to the court if they still want to go to court. Mediation is better because low cost, fast, confidential, empowering, informal, flexible, and low stress. You know, it's stress-free. Nobody is going to question you. Nobody is going to say, no, this is what you do. You wasted the court's time, go and do it by tomorrow itself. Nobody's going to say, we give enough time. Okay, we'll go for the next sitting. Before that, you fix all these things and email to us. Feeling versus facts. Court is fact, fact, fact. They don't care about anybody's feeling. Whereas in mediation, feelings are given importance. Any other thing you want to discuss? Anyone else, any other opinion about? Any other opinion about litigation and mediation?
Mediation opens a flow for the feelings, as you said, as litigation goes more by facts, but even when you go for litigation, the facts aren't seen with the emotions of the people. People might not be very genuine as they produce evidence in the court. Through mediation, even when we can see there is like a person's intention right through the case beginning, we can't go and end to a conclusion where we can provide justice.
Yeah, if you are genuinely interested in saving money and you really want to come to a solution for a win-win situation, both parties will come with open mind. That's what Eve was also talking and I was telling previously. If I want a solution and if you want a solution, we go to Saravanan, we go very open mind with all the things. We really want to solve it without litigation. So if one party is not going to do that, it's not going to go. Especially in families, the brothers fight for properties. If both parties really want a solution, okay, leave out the person, it's the problem. The problem is we want to get this property sorted out. And if they come together and we try to do things, it will work out. If one party is very secretive and very selfish, then it's not going to work. Mediation, you have to, when you go, you have to go empty hand and open mind.
It's also of the mediation agreement.
Yeah.
It's very difficult in India.
Yeah.
After having, any settlement.
The options, when you go, as you go, option. What I do is every time we go a meeting, for every session I do, whatever you agree, I don't let them go. I said, wait half an hour, because I use the technology a lot. While writing itself, it gets typed out. So anything I give the paperwork, and if they want any amendment, both parties agree, I correct it. Immediately I make them to sign. So that will go as my file notes and that will go into my thing. So 70% or 80% of the agreements which will be signed by both parties.
I'm talking about India, ma'am.
Yeah. India, everything is difficult.
Yes, that is why implementation is very difficult here. After
We'll go back and say we don't want to do that.
Yes, it was obtained by way of coercion, it was obtained.
Yeah.
By
Coercion, yeah.
like that.
Yeah, cohesive way sometimes. It happens there also. One of the client I had recently, so he said yes to everything, and the next day he said, I'm not signing anything because if I sign this, that means I agree for this. So we get such clients, but we have the records of what the conversation, file notes and stuff.
This apprehension has been taken care of in the Singapore Convention.
Yeah.
It is a relatively international dispute.
Yes.
Okay, once the parties sign the mediation agreement, it is deemed as a court case.
Yes.
So that has to come and, now that is made under the mediation.
Yes.
Once the mediation agreement is signed,
Yeah.
like
They can't go back.
Yes, it is executable.
Yeah, we'll go through that in the afternoon. We'll have a break now and then after the lunch we'll
Yes.
start. Thank you.
Thank you.